Did it. All right, we all good in the room, Milt?
Yes, sir.
Okay. All right, it is now 9:08 a.m. on Tuesday, January 16th, 2024, and I call to order this meeting of the Maine Gambling Control Board. My name is Steve Silver, and I'm the board chair. Before we go any further, I'd like to explain the circumstances under which we are holding this meeting and set up some ground rules for how we will be conducting the meeting. This is a hybrid meeting. There is a physical location today at 45 Commerce Drive in Augusta, Maine. We're also providing a virtual attendance option via Zoom. Today, in accordance with the board member remote participation policy adopted by the board on July 20th, 2021, I directed that today's meeting be conducted virtually through remote participation for the board pursuant to Section 2A and E of that policy. In support of this directive, I determined that based on the following circumstances, there exists an emergency or urgent issue which, pursuant to the policy, requires the board to meet by remote methods today. That being yesterday, January 15th, 2024, the National Weather Service issued a hazardous weather outlook for most of Maine for today due to the snow. And then 8 of Maine's counties are still under a state of civil emergency pursuant to the January 11th, 2024 proclamation by Governor Janet Mills due to the recent storms and flooding. So due to these factors, I determined that conducting an in-person board meeting was not practical for everyone. Since the unit staff, or at least most of them, were able to make it into the office, there is also a physical location of this meeting today too. So the board expects that all members of the public who attend the board meeting, whether virtually or in person, will be able to provide public comment the same. And so it looks like it's done. Everyone will be muted until it's your time to talk. When we get to the public hearing, I'll go over sort of how to work it both remote and in the room. But, if you need to say something, there's a little raise your hand button. You can use that. And I'll unmute you if needed. For the board, hopefully everyone can stay visible so I can see you. We'll just have to be a little patient, but we'll make it work. Also, the unit on behalf of the board posted notices of this meeting on its website with instructions on how members of the public could access the meeting. It works. I use the Zoom link online, so we're good there. Also, the unit on behalf of the board sends agendas in advance of the meeting. So it is the board's sincere hope that all those interested in the subject matter of today's meeting have received notice and how to participate electronically. So at this time, I'll introduce or ask the other board members to introduce themselves, confirm we have a quorum. So when I call your name, say who you are, where you're from. So we'll start with you, Ms. Green.
Hey everyone, Sarah Green right here and from South Portland, Maine.
Mr. Hanslip.
Good morning, everyone. Joe Hanslip, Sanford, Maine.
And I'm Steve Silver, also in South Portland. Chief March can't join us today, but we have 3 members present, which is a quorum, so we can get moving. In the room, I can see Executive Director Champion, and I think that's both Assistant Attorney Generals Philip Mantis and Jen Willis, right? Or is that Executive Director? Is that your assistant? I can't see who's sitting next to you. Sorry. Yes. Who else is at the table?
Amanda Spencer will be doing the financial report, and
Okay.
Jen Willis is here with us in person, and Phil Mantis is on Zoom.
Okay, got it. Sorry. And then I know there's some people in the audience, so I suspect we'll hear from some of them later today as well. So apologies, we couldn't be up there, but yeah, I'm not sure I'd get back. So we're going to do it this way. So with that, let's move to the approval of minutes from the November 15th, 2023 meeting. Joe, were you there remotely? You're on mute.
I was not. I'll be abstaining from the vote.
All right, so we got to put that on hold, right?
Not if he's abstaining.
Oh,
If
okay.
he's abstaining, he is still present for the purposes of the meeting and you can go ahead and vote.
Okay.
Right.
Well, Sari, I know you were there, so you want to move to?
Sure, I was there and I will move that we accept the minutes.
All right, I'll second it. Let's take a vote. Ms. Green?
Aye.
I'm an aye as well. Mr. Hanslip?
Abstain.
Okay. So we got 2 in favor, 1 abstaining. So with that, let's move to the operations report. Inspector Supervisor Vicky Gardner. Hi, Vicky.
Hey, good morning. I have 2 operations reports, one for November 2023. There were 12 shipments of machines and or associated equipment shipped to or from the licensed facilities. On-site inspectors completed 768 observations and 30 checklists. There were 8 self-exclusions, 7 minor violations that will continue to be monitored on our activity log. There was 1 patron's complaint and 0 formal complaints and potential violation placed on the dashboard. The Oxford Casino had 24 calls for service by Oxford PD, 4 in the parking lot, 2 in the hotel, and 8 in the casino, and they included 10 security details, medical, drug investigations, suspicious calls, intoxications, 911 missed dials, unwanted weapons offense, and traffic violations or crashes. Hollywood Casino had 18 calls for service from Bangor PD, 6 in the parking garage or outside, 5 hotel or lobby, and 7 in the casino, and they included 911 hangups, welfare checks, fraud, information, and agency assists. That was November's. We flip the page here. December 2023's operation report. There were 16 shipments of machines and or associated equipment shipped to or from the licensed facilities. On-site inspectors completed 779 observations and 27 checklists. There were 9 self-exclusions, 2 minor violations that will continue to be monitored on our activity log, 1 patron's complaint, and 0 formal violations or complaints of potential violations placed on the dashboard. Oxford Casino had 24 calls for service by Oxford PD, 5 in the parking lot, 0 in the hotel, and 19 in the casino. They included security details, disorderly subjects, trespass, theft, OUI, and intoxications. Hollywood Casino had 8 calls for service by Bangor PD, 3 parking garage, 1 hotel or lobby, and 4 in the casino. And they included fraud, PD crash, locked out, and traffic hazards. That completes my report.
Thanks, Vicky. When you say there were 9 self-exclusions, what does that mean? That they tried to get access or people who actually excluded themselves?
No, that would only be the ones that actually excluded themselves.
Okay. All right. Any questions for Vicky? Oh, got 2. All right. Ms. Green, go ahead.
It's not really as much a question for Vicky, but I was just curious why the operations report as well as the executive director reports don't get posted into Dropbox ahead of time. Is there a reason that they don't post?
I have no reason. I can make them available for the director to do that.
That would be great. Just be nice to be able to kind of look through them ahead of time and so we can jot down any questions that we have for you.
Sure.
Thank you.
Joe, did you have a question?
Yes, I did. Thank you. You reference about a detail at the casinos. Is that where a police officer, where it was at an outside paid detail called to be present?
No, these were details that were mostly weekend details in December anyways, and not in November, related to the October mass shooting in Auburn. They upped their security because of the location of the casino.
Right. Okay, thank you.
All right. Any other questions for Vicky? All right, seeing none. Thank you.
Thank you.
All right, we will move along to the financial report from Auditor Amanda Spencer.
Morning. This is the financial report for November and December 2023. Casino revenue paid to the state of Maine increased by 3.30% in November and by 7.16% in December 2023 for both facilities compared to the same months in 2022. Total tax revenue received through November 2023 during the year from both casinos was $64,583,701, an increase of 2.24% compared to the same month in 2022. The final 2023 year-to-date total tax revenue received through December from both casinos was $70,011,918. An increase of 2.61% compared to the prior full year. Specifically by casino, the Oxford Casino reported total net win from slot machines of 7.83% in November and 7.96% in December of 2023. Reported total win from table games was 25.49% in November and 21.98% in December of 2023. The Hollywood Casino reported total net win from slot machines of 9.11% in November and 9.12% in December of 2023. Reported total win from table games was 21.66% in November and 21.66% in December of 2023. Regarding advanced deposit wagering, we observed a decrease in 10.9% for November and a decrease of 23.9% for December of 2023 compared to the same months in 2022. Total 2023 year-to-date tax revenue collected by the end of December from in-state and out-of-state races was $234,641, a decrease of 12% compared to the prior full year. That concludes the report.
Thank you.
Any questions?
Maybe a question for the casinos, but any explanation for the drop in table revenue?
I recall there was, I don't know. Is there any?
Yeah, with Oxford in December, we did have a couple of larger winners,
Yeah.
normal operations.
Okay. Didn't know if this was a trend or, something we need to look at.
No, I didn't see that.
Okay. Yeah, I mean, slots are up. Look, increasing, almost 3% is pretty good in this climate, and $70 million to the state is nothing to sneeze at. So, just commend everybody for a job well done. It's, there's been difficult times this year for sure. So, so that looks good. And, I assume ADW, I know there's a nationwide drop in races, and then we've got sports betting. So there's only so many dollars to go around. But any questions for Amanda? All right, thank you. All right, moving on to the Executive Director report with Executive Director Milton Champion. Take it away.
Yes. Good morning, everyone. We are now in the 131st regular session of the Maine legislature. There are currently 4 agency bills in the works and 3 that have had public hearings. Some of these may not fall under the regulatory oversight of the board, but I'll just mention them here today. Tomorrow morning at 9 o'clock, there's going to be a public hearing on LD 2070, which amends the laws relating to the auditing and security of slot machines by replacing the requirement that the Department of Public Safety maintain a central monitoring system with a requirement that all slot machines communicate electronically with an on-site facility-based monitoring system that is accessible by the department. LD 2080 allows individuals to voluntarily exclude themselves from a slot machine facility, casino, advanced deposit wagering, a fantasy contest, or sports wagering collectively or separately, and also allows the Department of Public Safety, Gambling Control Unit, and licensees to work with a universal list and not a list for each separate area of regulation. The bill also includes provisions for the inclusion on the universal list of individuals who are involuntarily excluded from a slot facility, casino, advanced deposit wagering, a fantasy contest, or sports wagering. Also, the only thing what I want to add into this is it also brings forth the legacy list from each casino and incorporates those lists into this universal list. LD 2108 allows the Department of Public Safety Gambling Control Unit to impose a fine of not more than $100 per violation on Vino or games of chance, licensee or registrant, or a licensee or registrant's agent or employee that has violated laws or rules governing Vino or games of chance, subject to an appeal and hearing before the Commissioner of Public Safety. It also allows the issuance or the issue of the imposition of such a fine to resolve by the execution of a consent agreement. The bill removes the provision that no more than one registrant may operate a game of chance at a time on the same premises, and provides an agricultural society must determine the number of registrants permitted to operate a game of chance during the annual fair of the agricultural society. It also provides that a bona fide nonprofit organization may operate a registered game of chance to which the general public has access no more than 4 times in a calendar year for a period not to exceed the duration of the annual fair or an agricultural society, or the duration of a special event, rather than a period not to exceed 4 consecutive days as in current law. LD 2117 amends the laws governing the regulation of sports wagering licensing. It lowers the fee for an initial and renewal license in all areas from a 4-year license to a 1-year license with no change in fees, and provides that the term of a temporary license may be extended. Other bills addressed so far in public hearings, LD 1777 authorizes each federal recognized Indian nation, tribe, or band in this state to operate internet gaming pursuant to a license from the Gambling Control Unit within the Department of Public Safety. Only a federally recognized nation, tribe, or band in this state is eligible to obtain the license or operate internet gaming. The licensing structure follows the law governing sports wagering, and the law governing sports wagering is also amended to remove mobile sports betting, which the bill regulates as internet gaming. LD 44 requires a state to negotiate with any federal recognized tribe in the state or any combination of federally recognized Indian tribes in this state that wishes to own or operate a casino on tribal land for a license to operate a casino. The state also may negotiate with all of the federally recognized Indian tribes in this state for a license to operate a casino on land that is not owned by the tribes in a county other than Penobscot County or Oxford County. The license to operate a casino on land that is not owned by the tribes would be in addition to licenses negotiated to operate casinos on tribal land. The negotiations between the state and the federally recognized tribe, combination of tribes, or all the tribes must include, but not be limited to, taxes and regulations governing the casino. And the last, LD 1992, authorizes the licensed operation of electronic Vino terminals and historical horse racing terminals by federally recognized Indian tribes, off-track betting facilities, commercial tracks, slot machine facilities, and casinos. Licenses are issued by the Director of the Gambling Control Unit within the Department of Public Safety. The bill requires an operator of an electronic Vino terminal or historical horse racing terminal to collect 10% of net terminal income for the distribution to the general fund for administrative expenses of the Gambling Control Unit, and to gambling addiction prevention and treatment services, harness racing purses, and agricultural fairs. And then finally, as a matter of interest to the board, on Wednesday, January 10th, Oxford Casino inadvertently sent out emails to possible recipients of their email drawing promotion, which in their rules indicate that every Wednesday, Oxford Casino would select randomly 5 reward members that would receive $250 in free slot play. Since the drawing and the retraction, there have been 491 complaints. After review of the promotional rules that have been available since inception on July 28th, 2021, the corrective notification and understanding of the basis for complaints, my position is that there is no factual dispute as to what had occurred. And while true that it did take place, the facts do not constitute a violation of board law or rules. Therefore, my conclusion will be that the complaints shall be dismissed. And that is my report.
Thank you, Director Champion. So there's a lot to unpack there. I don't know, is Matt in the room from Oxford? Talk
Yes.
about what happened with the mailings?
Yes, sir.
Like, when were they sent out? When was the correction sent out, I guess?
It was sent out about 2 o'clock in the afternoon, and he sent the retraction email around 2:50. So in the meantime, we were able to get Director Champion on the Senate floor of the House, and we were able to talk through it.
Who got was it sent to everybody?
It was sent to a list,
Okay.
a different list of who normally would get a promotional email, just updating people on what was happening during the week. It was a human error, 100%.
Yeah.
Clicked
Okay.
on the
So
wrong one.
within an hour, I mean, unless you lived really close to the casino, I don't even think you could see that and get to the casino to try to take advantage of it. What has been communicated to folks, like in the retraction and anything else? Like,
The retraction was an apology. And after discussion with the Maine Gaming Control Unit, we basically rolled it back.
okay. Any questions on this point while Matt's standing up on the board? Okay, thank you. Milt, I assume there may be workshops with some of those bills coming up. I guess, the one concern with the Beano and the historical horse racing is if it were to occur in the casino, I'd like to avoid a situation where you have some square footage that suddenly is not under the board, like a sports book, and then we're dividing up the facility in a weird way again. Would be my comment on that. I don't really have an opinion on the policy of doing this, but I don't know if you can make that known if there is a workshop.
Yeah, absolutely. They've had the public hearing. Now we'll go into a work session.
Yeah, I mean, there's so many of these bills, and I think they by default put everything under you in the unit without understanding how it works. So I did submit testimony in opposition to 1777, not on behalf of the board, but as myself individually. So everyone can go look it up. I don't have to restate what I said, but we just finished a year with $70 million delivered to the state from our two facilities, and we want to penalize them moving forward. It doesn't make sense to me. So, for those in the room, if you need something from me, let me know, because in my opinion, the legislature is not understanding what we do and what the facilities do for the state. But that's my opinion, not the board's opinion.
It's actually my opinion as well.
Okay. So a majority today. But so you can look it up, see where I'm at. But keep us posted. There's just a lot going on at the legislature, Milt, in terms of workshops or hearings. I think a lot of it is just, sometimes copy and pasting stuff from other places, and then you've got to deal with it in rulemaking, and we should try to deal with it on the front end. So yeah, any other questions for Director Champion? Go ahead, Ms. Green.
So I have the same request for the director as Inspector Gardner, if possible, if we could get those executive reports posted in Dropbox. Today there was just a ton and hard to follow and get notes and be prepared to ask questions. So that would be really wonderful if that works for you. Director, I was also curious if there were any of the proposed legislation that you plan to testify strongly in favor, for, or against.
Well, the four agency bills, I'll be testifying that, I want to get it approved. They're agency bills that we submitted, meaning they came from the Gambling Control Unit or from the Department of Public Safety. They were generated by us, so naturally we're going to.
So historically, have those ever been looked at or submitted to the board before you send them over to the legislature just for feedback? Does that ever happen?
No, not necessarily, no. Because some of it's gambling control related, or some of it's like charitable related, the fantasy one, the universal. Not in some cases, maybe, but not always.
Okay, thank you.
And the board, let me add to that, the board can direct me to put an agency bill in for future reference if you'd like to do that.
Thank you.
Yep. Any other questions for Director Champion? Milt, any progress on getting a new board member to fill Dr. Brown's seat?
It's still being worked on. Last time I heard, we did have a candidate, but I don't know where that candidate's position is right now at this point.
Okay. I assume the governor's office knows. Does the board need to send something? Or are we're just waiting for people to, apply?
Yeah, the unfortunate thing is it's specific to somebody from the harness racing area. And so that's where we put our attention out to, like the Harness Commission, the Harness Association, looking for assistance from those folks.
Okay. All right. Well, let us know if we can do something. All right. With that, I will let you go. We've got 2 license applications this month. One which I had held over from November was with Oxford Casinos license renewal. So let's take that first. Let me pull this up.
Let me go close it.
All right, so we will be reviewing the application of Oxford Casino to renew their casino operating license pursuant to 8 MRSA Section 1001 et sec. This is not adjudicatory proceeding. Instead, we will be receiving an opinion from board staff supported by evidence obtained during an investigation. We'll also provide the applicant with an opportunity to be heard. Finally, the public is also invited to participate, and time will be allotted for comment. So the applicant seeking to renew their license is Oxford Casino. I know there's people there in the room. I assume, Matt, you
Yes, sir.
yeah, and I should say the applicant's business name is BB Development LLC, doing business as Oxford Casino Hotel. So before we proceed, I assume one of the AAGs might have some questions for us.
Yes, thank you, Chair. I'm happy to do that. Does any member of the board have any reasons such as personal bias or conflict of interest that would prevent him or her from rendering an impartial decision in this matter? Seeing and hearing none, does any other person present at the hearing believe that there is any reason that would prevent any board member from rendering an impartial decision in this matter? If so, please stand or raise your virtual hand, state your name for the record, and state your objection and the basis for that objection. Seeing and hearing none, if there are objections to any pre-hearing proceedings, that is the procedure of this case up to this point, please stand, state your name for the record, and state the objection and the basis for that objection, or raise your virtual hand to do so. Seeing and hearing none, Chair, you may proceed.
Okay. So each board member has a briefing paper based on materials the board staff is relying upon to support its opinion. Those materials will become part of the public record. Mass copies are not available for public distribution at this time since some of it's confidential, but if anyone wants a copy of the public portion, please speak with Executive Director Champion and he'll arrange to have those materials provided to you. I don't think we'll need this today, but if the board has to go into executive session to discuss confidential portions of the record, we will do so, and all other materials will be discussed in public. All other evidence, conclusions of the board staff, statements made by the public or the applicant will become part of the record. So I don't know, anyone from Oxford have anything to say or present?
Not at this time.
Okay. So we're going to Detective Armstrong.
Yes, sir.
All right, there you are.
Pursuant to Title 8, Section 1005, subsection 2 of the Maine Revised Statute, the Department of Public Safety is responsible for investigating the qualifications of each applicant before a license or registration is issued and reporting to the board the results of any such investigation. BB Development LLC, Matt Gallagher, General Manager, applied for renewal of the company's casino operator's license on March 3rd, 2023. The company disclosed and was verified that since the company's last application for a board license, there have been no changes to the company's address. There have been changes to the key executives of the company or any parent or intermediate affiliates of the company. There have been no changes to the ownership structure of the company or any parent or intermediate affiliates of the company. There have been adverse actions taken against the company or any parent or intermediary affiliates of the company by any other regulatory agencies, and there are charges pending against the company or any parent or intermediate affiliates of the company in any state or federal court. The company submitted its federal and state tax returns for the preceding year 2021 and copies of its internally prepared financial statements for the current year 2022 as of the close of the most recent fiscal quarter prior to the application. Those financial documents and other documents as required were supplied to our financial review contractor, Whitfly. Whitfly reported that the company BB Development LLC appears to have sufficient financial assets to meet any financial obligations imposed by the board. Additionally, the key executives for BB Development LLC were found to have demonstrated financial responsibility as defined by the rules governing the board. The department has investigated the qualifications of BB Development LLC and has determined that it meets the board's requirements for renewal of its casino operator's license. Specifically, BB Development LLC and its principals continue to meet the qualifications for a license set out in Title 8, Sections 1016 and 1019, and meets the requirements of Board Rules, Chapter 2, Section 2. Therefore, after my verification of the documents submitted, interviews or inquiries, the financial review by Whitfly, and the final review by Director Champion, it is the opinion of the department that BB Development LLC is suitable to continually licensed as a casino operator in the state of Maine.
All right, thank you. Any questions for Detective Armstrong? Okay. Anything from you, Milt?
No, sir.
Okay. Any public comment on this application? Okay, hearing none. I'll also note in the Dropbox, there's a approval from the town of Oxford, which is obviously important. So, yeah. So anyone want to make a motion on the application of BB Development LLC doing business at Oxford Casino for renewal of their casino license?
Green, I make a motion for renewal of BB Development renewal license.
All right.
Seconded, hand slip.
Okay. Anything to discuss? Probably not. Okay, let's take a vote. So if you vote aye, it is to renew the application. We'll start with you, Ms. Green.
I vote aye to renew.
Mr. Hanslip,
Aye to renew.
I'm an aye as well. So that's 3-0, having met all the requirements of licensing pursuant to Title 8, Chapter 31. BB Development LLC, doing business as Oxford Casino Hotel, I guess Hotel and Event Center. Is that the full name now? Will have their license renewed. Obviously, thanks for continuing to do business in Maine. That would be a change tomorrow. So let's move on to our second license application for review. This is a slot machine distributor's license from LNW Gaming, right? Light and Wonder, right? Let me bring this up. Okay. All right. So we are reviewing the application of LNW Gaming Inc., which is formerly known as SG Gaming Inc., to be licensed as a slot machine distributor or have their license renewed as a slot machine distributor pursuant to 8 MRSA Section 1001 et sec. Again, this is not an adjudicatory proceeding. Instead, we'll be receiving an opinion from board staff supported by evidence obtained during investigation. We'll also provide the applicant and the public opportunities to be heard. Is there anyone here from LNW? Okay, I don't think so. Seeing no representative, will continue. And before we proceed, I believe Assistant Attorney General Mantis has some questions again.
Thank you, Mr. Chair. Does any member of the board have any reason, such as personal bias or a conflict of interest, that would prevent him or her from rendering an impartial decision in this matter? Seeing and hearing none. Does any other person present at the hearing believe that there is any reason that would prevent any board member from rendering an impartial decision in this matter? If so, please stand, state your objection, or raise your virtual hand, state your name for the record, and state your objection and the basis for that objection. If there are objections to any pre-hearing proceedings, that is the procedure of this case up to this point, please stand or raise your virtual hand, state your name for the record, and state the objection and the basis for that objection. Seeing and hearing none, Mr. Chair, you may proceed.
Okay. Again, board members have received materials the board staff is relying upon to support its opinion. Some of this contains confidential information, but everything that's not will be made available to the public. So if anyone would like public portions of the material, please speak with Director Champion. And any other evidence today, including statements by the board or the unit staff, will become part of the record. So with that, we're going back to Detective Armstrong.
Yes, sir.
All right.
Pursuant to Title 8, Section 1005, subsection 2 of the Maine Revised Statute, the Department of Public Safety is responsible for investigating the qualifications of each applicant before a license or registration is issued and reporting to the board the results of any such investigation. LNW, Light and Wonder, Gaming Inc., Amanda Bayett, licensing analyst, applied for renewal of the company's slot machine distributor's license on September 1st, 2023. Company disclosed and was verified that since the company's last application for a board license, there have been no changes to the company's address. There have been changes to the key executives of the company or any parent or intermediate affiliates of the company. There have been changes to the ownership structure of the company or any parent or intermediate affiliates of the company. There have been adverse actions taken against the company or any parent or intermediary affiliates of the company by any other regulatory agencies, and there are no charges pending against the company or any parent or intermediate affiliates of the company in any state or federal court. The company submitted its federal and state tax returns for the preceding year 2021 and copies of its internally prepared financial statements for the current year 2022 as of the close of the most recent fiscal quarter prior to application. Those financial documents and other documents as required were supplied to other financial review contractors, Whitfly. Whitfly reported that the company LNW Gaming Inc. appears to have sufficient financial assets to meet any financial obligations imposed by the board. Additionally, the key executives for LNW Gaming Inc. were found to have demonstrated financial responsibility as defined by the rules of governing the board. The department has investigated the qualifications of LNW Gaming Inc. and has determined that it meets the board's requirements for renewal of its casino operator license. Specifically, LNW Gaming Inc. and its principals continue to meet the qualifications for a license set out in Title 8, Sections 1016 and 1019, and meets the requirements of Board Rules, Chapter 2, Section 3. Therefore, after my verification of the documents submitted, interviews or inquiries, the financial review by Whitfly and the final review by Director Champion, it is the opinion of the department that LNW Gaming Inc. is suitable to be continually licensed as a slot machine distributor in the state of Maine.
All right, thank you. Any questions for Detective Armstrong? Okay. Milt, anything to add?
No, sir.
All right. Any members of the public have any comments on this application? Okay, hearing and seeing none. Is there a motion on the application of LNW for renewal licensure as a slot machine distributor?
Green, I'll
Motion.
make it. Oh, go ahead.
Hand slip.
Second, Green.
Okay. Anything to discuss? All right, let's take a vote. Ms. Green,
Aye.
Mr. Hanslip,
Aye.
I'm an aye as well. That's 3-0, having met all the requirements of licensing pursuant to Title 8, Chapter 31. LNW Gaming Inc. Will be licensed as a slot machine distributor in the state of Maine. And of course, we thank them for their continued desire to do business in Maine. So with that, we can move to unfinished business. Let me switch gears, pull this up. So we've got a couple internal controls. We'll start with Oxford first. So I don't know, Milt, I don't know if you want to tee this up or just have Oxford go.
Yeah, well, basically, and I think we already addressed this at the last meeting, there was a couple issues that needed board response, and that was taken care of. And if Matt wants to add any more to the application.
With those changes,
Yep.
we're comfortable as written.
Okay, and is there anything, so there's some references to like excluded patrons, but there's no actual section of the internal controls about what the process is for dealing with them? Like, is that?
I don't believe it is part of the mix. I believe it's part of the rules. We do have SOPs supporting
Okay.
that outside of the internal.
Okay. Any questions for Matt or anyone at Oxford from the board? Okay. Yeah, I mean, we addressed those issues last time. I think everything, I went through them. I mean, everything else looks in order to me. So with that, I guess, so we would need a vote to approve them. Is that right?
Yes.
Okay. All right. Anyone want to move to approve the internal controls or the amended internal controls for Oxford?
I guess it's my turn. Green, I will motion to accept the amended internal controls for Oxford Casino.
Okay.
Hand slip.
Okay. Let's take unless anyone needs to discuss anything. Nope. Okay. Let's take a vote. Ms. Green,
Aye.
Mr. Hanslip,
Aye.
I'm an aye as well. So
Thank you.
I know that's can be a heavy lift to go through all of that. But we got those through. Let's move on to Hollywood Casino, and I think there's still outstanding things we didn't address last time.
I think we addressed them all, and I believe all were approved.
That's good.
Okay, all right. Anything else specific, Austin?
No, I think we addressed all the issues the last meeting, and like Matt, we are comfortable with having the group as written.
Okay. Any questions for Austin? All right. So someone want to make a motion to approve the internal controls for Hollywood Casino? Whose
Motion
turn is
to
it? Okay. Joe moved. I'll second it. Let's take a quick vote. Ms. Green,
Aye.
Mr. Hanslip,
Aye.
I'm an aye as well. So got that taken care of. Glad to get that done. All right, moving on. About the casino surveillance rule update. Milt, are you handling this?
Yeah, so basically, we made some attempts for the surveillance folks and for IT folks to meet with board member Green. And during that time frame, she specifically asked for something from, I believe, the surveillance people, which I guess we provided. She wanted something in writing. This rule development has surpassed the time limits. And so that's why I'm presenting to the board today proposed language of specifically in Chapter 17, just going ahead and striking and meet the Profile S and Profile G standards. I think through the several discussions that we've had with the surveillance folks and the IT folks, that probably there's not a rifle standard to go by. There were some examples, but at the end of the day, we all know what remote access is. And so I'm proposing that instead of being specific on any type of standard, we just utilize the term remote access. And then that would give the ability for individual surveillance companies, for IT companies, Maine IT, to weigh in on that remote access. So that's kind of where we're at. And, unless board member Green wants to add anything, I think that's the only way we can go with this.
Ms. Green, this is
No, I do have something to say.
yeah.
So I've heard from the casinos and from the vendors. Thank you very much to all of you. Despite repeated requests, I have not spoken with nor received any documentation from the department or any state IT representative as to their perspective. Currently the casinos have a closed loop network. The remote surveillance system would breach that barrier and it would create a conduit into the casino network that could potentially be exploited. I don't think the Gambling Control Unit has made a compelling case as to the necessity of remote surveillance. And personally, I think until such time they do, and it's determined that it outweighs the risk to the casinos, its patrons, and ultimately to the state, I would continue to recommend against implementation of remote access surveillance.
So what's happening now? Like, how does it work now?
There is surveillance, it's internal. There is no remote access surveillance right now.
And so the internal access is what we saw for the state has the room in the facility.
Correct. Has an inspector, has a room, has access to the surveillance.
Okay, so if we were to vote to publish this proposed text, it would then go through a comment period?
Yes. 30-day written comment. We wouldn't have a public hearing on this.
And then after the comments, the board could vote to not go forward or to remove remote access?
Well, you would be a part of the final adoption. So you could not approve it.
And if we decline to approve publishing this?
Then it wouldn't get published and we just go on in a normal fashion.
Okay.
I got to be honest and say that remote access is happening right now worldwide. The specific surveillance companies that are licensed in the state of Maine offer remote access, have server centers that offer remote access, that remotely are attached to whatever businesses. We do have a sports wagering facility that's going to have remote access. In other words, they will not have surveillance in their facility. They will be covered by a third-party surveillance company. Remote access is going on right now. So I'm finding it really hard to understand why we can't have this done.
Well, there's also an increase in breaches and other security threats. So it's not a end all be all.
And the casinos are not in favor of it, and we already have on site, and there's just I understand remote access, but there's no reason at this point, or at least I don't believe that the unit has made any compelling argument as to why we need to introduce a potential conduit into the network when we have on-site inspectors right now. And so my perspective is the time there's a compelling argument, I don't see why we would introduce this level of risk.
And that's fine. But, my thought pattern around this was it's required under the sports wagering rules. And therefore, I thought, well, if there's going to be 20 cameras covering the sports wagering area within the casinos that would have to have remote access to us, that why not have all of it? So if
Well,
that's
but
the
isn't
case.
But that's that's bizarre disconnect we have right now, right? That you were able to put something into the sports deck rules there that we don't have any visibility, yet we're responsible for oversight of the casinos. And so just because something got put in those rules doesn't mean that it's the appropriate thing for the casinos.
And maybe Oxford or Hollywood could speak to this, but isn't it, they're going to be separate? That remote portion is going to be separate from the rest of the surveillance in the casino.
You can
Thought
answer
that's
that, Bill.
Yes, in theory, they're going to be compartmentalized and it would be a specific grouping of cameras.
Yeah, because you don't want the remote access into the full facility, right?
Yes, we're going to take every step we can to limit the risk that Ms. Green has talked about to the degree possible.
Yeah. Okay. Well, I'm going to trust Miss Green here, Milt. So that's 2. I don't know where Joe stands, but I'm not leaning in favor of moving forward with this. So do we need to vote to
Yeah.
not publish?
That would be advisable to have a motion, a second and a vote. Yes.
All right. So Miss Green, this is your
Sure,
your
I'll
area
make-
of expertise if you want to move to not publish this.
I would move that we not publish the surveillance with remote access rule.
Okay.
That-
All right. Well, I'm going to trust Board Member Green here, given your expertise on this. Maybe there's some reasons for doing this, but it increases the level of risk, and I think we have to trust the casino operators too, as to what they have to say about it. So, yeah, let's take a vote. So if you're voting aye, you are voting to not publish this rule. So, Ms. Green,
Aye.
Chief or Mr. Hansler.
Thank you for the promotion. Aye.
Yeah. I'm an aye as well, so we are not going to publish this rule. And I do appreciate the efforts by Ms. Green outside of, normal board duties of getting knowledgeable and informing us about this, and for the all the entities for cooperating. So yeah, I really appreciate it. So let's move on to new business. We have an annual report to the governor and the VLA committee due in March. So I believe that means we need to approve or amend whatever the annual report now, right, Milt?
Yes.
Okay. Anything to add or discuss about the report? I assume that was no from you.
Oh, with me?
Yeah.
No.
Okay. On, hold on, let me pull it up. So on page 3, where it talks about the board composition, there's a final paragraph. It says members who served on the board in 2023 include, like, should we add Dr. Brown because she was on in 2023, and then maybe a line that, I don't know, her term ended and we currently have a vacancy.
That was going to be my comment as well. I think it's important to highlight that there is a vacancy.
I
You see
agree.
where it's the very last paragraph under board composition. And she did serve in 2023, so I think we add that Dr. Brown was there. Her term ended, I don't know when, sometime earlier, I think in September, and we currently have a vacancy on the board.
Okay.
Yeah, that was the only addition I was thinking. But Joe or Miss Green, if you have anything else, you can chime in. Okay. I don't know who really will read that in depth, but I want to highlight that, we are operating a person down. So maybe somebody in the governor's office sees it.
Okay, we'll add it.
All right. And again, the financials, I think it's really useful seeing this, everything broken out, seeing also the cascade of, who gets what in the money at the end of the year. Very interesting. Which I highlighted to the VLA committee, and hopefully they understand, all the beneficiaries of the work that goes on. So yeah, good report. Always good to be going in the positive direction. Any other comments from the board on the report?
It's not as much on the report, but sort of ancillary to that, and what the director was talking about, requests that maybe for legislation. At some point, could we revisit the necessity of a board member having harness racing experience? I don't know how much that's a holdover from when harness racing was a much larger component of gambling here in the state. It feels pretty antiquated to me, and maybe we could revisit that.
Yeah, for sure. I think the legislature would have to do that because it's by statute, those positions. But particularly given, given what we've seen with the tech and everything else, might want to update the backgrounds everyone needs to have. But I'm sure the harness folks will have something to say about it, although they haven't been able to find us a nominee. So pretty good idea. Maybe we should do that next session.
Sounds like an agency bill to me.
Yeah, I mean, right, because there's other just descriptors of what the positions have to be, and maybe it's time that the legislature revisits it, because I'm sure they haven't in 10 years. So, yeah, Okay. Yeah. Well, next session, maybe we'll be busy. All right. So I think we need a vote to approve the annual report with that one amendment. Is that right?
Yes.
Okay. Um,
Green, motion to accept the annual report with the amendment highlighting Dr. Brown's service and the vacancy.
Seconded, hand slip.
okay. Let's take a vote. Ms. Green,
Aye.
Mr. Hanslet,
Aye.
I'm an aye as well. So one edit, Milt, and then you can get that off.
Sounds good. Thank you.
All right. All right. So moving on, we have two different facilities, but multiple sort of incident reports for the board review. I'm not sure who wants to take the lead on this, Milt.
Well, basically, as everyone knows, in the last year, we worked on Chapter 13 in regards to self-exclusions. We've had various incidences over the period of 2023, and I believe I don't think they go back before that. Doesn't look like it. So 2023, we basically put all these incidences of self-exclusion on hold until the board made a final decision on Chapter 13, which they did. And so now we brought forth these incidences. Basically, there was 8 at one facility, one licensee facility, and then 1 from another facility. And so with the process, we brought this forth to the investigative committee, and because through the discussion of Chapter 13, we know that the board wanted to look at these individually. And so rather than the investigative committee make a decision, it was decided, and Jen, correct me if I'm wrong, but it was decided that we would bring these particular incidences forward to you or to the board for the handling of these. Aside from us making a determination, we thought you want to weigh in on these individual cases.
And what are you looking for from us today? A decision on discipline?
Yes.
Is
Yes.
each So I see that, for instance, I'm looking just because it's sequential. There's GCU 2023-79. So are all the incidents, I think there's 8 in there. Is that one? Or do you take each incident by itself?
Well, we basically did it, bringing forward 8 prior incidences all forward into one rather than addressing you with 8 different incidents. So it's collectively all one. You can find, you can find whatever situation, 3 hold water, 2 don't, whatever the board wants to decide to do.
And what have there been any incidences, I don't know, since October 18th, when we when we put in essentially the ID rule.
Can I answer that?
Milt, do you have an answer?
What's that?
Can you answer the question? Because it would be preferable if Milt answers the question.
Well, this was generated on October 16th as a result of the board's final decision on Chapter 13. And so the other cases here are back from pre-October, basically from up to the last one was October 9th. So these are all pre-October adoption by the board.
So are we being asked to retroactively apply a rule or apply our October 18th decision?
Yes.
No. Oh, we are? Who said yes?
No, nothing necessarily changed in regards to these violations. The groundwork for these were allowing access, and that did not change. And so therefore, that's why we brought these particular
Well,
cases forward.
yeah, I get that. What changed is we made it clear that we are going to look at a failure to ID differently than in the past, where the practice was sort of IDing people who observed to be under a certain age. So I think there is a change. But go ahead.
Chair Silver, are you recognizing me?
Yeah.
I had my hand up. Thank you. This is Jennifer Willis. We are not recommending, we would not recommend, your AAGs would not recommend that you retroactively apply the October rule.
Yeah, I
You should
assumed
only
as much.
consider, you should only consider the pre-existing rule and should not apply retroactively the rule that was passed on October 18th. You should look only at the former rule language to consider these pre-October self-exclusions.
Yep. Yeah, and that's how I was viewing it. Although they highlight exactly the reason why we went through the rules, because we should know who's coming into the casino. Obviously the patrons have to have some level of personal responsibility about it, but there's a variety of reasons to not allow self-excluded persons on, and to know who's coming, because there's a lot of nefarious things they could do. But we have these incidents. They're sort of detailed in the Dropbox. The response from the facility is also in there, and what they request. So I don't know. I have some thoughts, but I'll open it up to the board as well.
Just AG Wells, could you just, I'm sorry, just clarify for us? I know we're not going retroactive. So what is the criteria, please, that we need to review these particular incidents on? Is it just that because I think it was that they once recognized they took an action. But if that's not accurate, I'd like to know, please.
Yeah, I think the former rule was refuse access was the requirement without specificity. And so the question is whether there was a refusal of access or not. I think the board could also refer this back to the investigative committee for individualized recommendations and comparison to the criteria if you so choose.
I like that idea. I mean, it feels like there's, I don't know, personally, I feel like they took action on all of these as soon as they were noticed, and we weren't asking them to do IDs. Well, we weren't stressing the need for IDs when they entered the facility. But I guess I'm interested in what others have to say here.
Yeah, I mean, the way I see it, on some of these, it was close. I mean, there's the one issue that triggered an alarm, but they still accessed the floor. That one, they were removed prior to actually gaming, but I guess, we may need more detail on that one. Like, how does that physically happen if the alarm went off? But on the other ones, they were discovered either quickly or the checks, right? So they go to player services. There's those checks that happen where there could be contact, and they worked. And then you have one where actually the person was recognized by the staff and removed, which is another check on the system. So I guess to me, what stands out is I would lean towards dismissing all but the alarm one, sending that back to get some more detail as to what happened, right? Because they were ID'd, triggered an alarm, but then they still accessed the gaming floor. Now they didn't game, but
Well, it says they accessed the gaming floor prior to the alarm going off.
Right.
Was ID triggering an alarm, however, the patron access the gaming floor prior to the alarm. And then
So how, but so how did that like, how's that happen, I guess?
that I don't have an answer to, but
Yeah.
but I guess it just, it doesn't sound like the alarm was going off and then they got on, that's all.
Austin has a comment on that, Chair, if you'd like to address.
Go ahead, Austin.
Yeah, so because of the amount of names we have to put through the system, there is I think it's a 7-second delay. We've tried to speed it up, but there is a delay from the time that there's a swipe to the time that the alarm will actually trigger. And so I believe that's the amount of time that elapsed. It was literally okay, you're free to go. And then the alarm went off and they immediately went and stopped the patron. So I don't think they got any further than a couple steps in.
Got it. Okay. But yeah, I mean, when you look at it, right? Okay, they weren't ID'd. Obviously, I believe that they should be, but so be it. That's how we were operating. But you know, the slot monitoring system or player services, whenever there's contact where they could be identified, they were, and they were removed. And that's what we expected of the facility at the time. But so I guess I wouldn't go as far as outright dismissal. I don't know if we can, issue a written warning, something such that if there are later violations, we can still consider these. Jen, I don't know if you have thoughts or advice on that.
Certainly, you have the option of issuing a letter of guidance or of concern that takes into account the concern that you are expressing about continuing to enforce self-exclusion rules. And that is not formal discipline, but it can be kept for the board's records for a period of time. And at that period of time is 10 years. So you could keep it on file and it would come up to your attention anytime there was a complaint about this issue.
Well, and my thought, and this is me, this isn't everyone else, we'll open it up, but my thought is that if there are violations moving forward where they're, supposed to ID or whatever, they don't have to, but at least post the rule change, then the committee could consider these prior things, right? And it's not a surprise to anybody, right? That's in there. And but I don't know. Ms. Green, Joe, do you have any additional thoughts? Go ahead, Joe.
Thank you. I like the idea of a letter of concern, but well, we'll just leave it there. I think that's the way to go.
Sorry.
I'm okay with that, but I think they were handled very well. And I guess, given sort of what the rule was in place, in all cases, they were found, they were escorted out, they got, with the exception of maybe one or two, they got a 1-year no trespass notice. I guess I don't have concerns about these particular issues, and I do think that they were handled fairly quickly in most cases and handled well.
Joe?
Thank you. Ms. Green, my idea behind a letter of concern was simply to document these incidences. But whereas they're reflected in the report, I don't feel as strongly about a letter of concern.
Yeah, I could go either way here. I think, go ahead.
Pardon me. I was just going to say the next step in a letter of concern, if we go down that route, would be I would need you to tell me what you want it to say specifically. And so that may help decide you one way or the other. Like, what specifically would you want a letter of concern to potentially say, given board member Green's framing of the issues?
Yeah. Um, okay.
And again, noting that the rule has changed since these incidents occurred, so we wouldn't be enforcing the same rule in any later violations.
That's true. Yeah.
Yeah.
Good point. That would get tricky if you were using. Yeah.
And we have this, I mean, I realize we may not be able to refer back to it specifically, but it is documented already. We have these incident reports. So we have a historical record. So I don't see why anything more is necessary.
Yeah.
I agree.
Okay. So sounds like there may be leaning towards a motion to dismiss these violations. Is that what I'm hearing?
Yes,
Somebody want to make that motion?
sure. I'll make a motion to dismiss the incidents. I don't know if there's anything more that has to be in that motion.
I think it would be the incidents reflected in the inspector report GCU 2023-79.
So noted. Agreed.
Second.
No. Is that an accurate description, Jen?
Yes.
Okay. All right. Well, let's take a vote. Ms. Green,
Aye.
Mr. Hanslip,
Aye.
I'm an aye as well. So dismiss those. I think everybody knows where we stand moving forward. So it may not be so easy next time. But let's move on because this is a little different. In GCB 2023-80. So Milt, or I don't know, somebody want to walk us through this? I guess same issue, right? The committee wanted to bring this to the board for guidance.
Yeah, because prior meetings, you said that the board wanted to look at these individually, so that's really why we brought them forward to you.
Yeah.
And so, yeah, that's kind of where we're at to get some direction. So I guess going forward, anything related to chapter 13 we'll bring to the board for your direction to go whichever direction you want to go into. So
Yeah, well, and hopefully there's less of these moving forward. But I guess my concern here, and I'm not sure if Milt or one of the AAGs has the answer here before we turn to the casino, but there was a jackpot won with hand pay. How does that get paid without an ID? Like I thought that the jackpot was one of those things that would trigger finding out who's going in the casino.
Matt Gallagher from Oxford can address your questions, Chair.
Well, hold on. Philip, did you have an answer?
Well, I just, based on the incident report, it looks like the payout never occurred to the patron. The patron absconded from the casino after the jackpot was triggered.
Oh, okay.
So
Matt.
yeah, and again, and I just want to highlight that one major concern with this incident is that it's presumed that the person who won the jackpot is an individual on the exclusion list. That was never actually verified, at least see any evidence of verification. So I just want to bring that to the board's attention as well.
Okay. Matt, do you have something to add?
Yeah, AG Bendis is correct. It was not paid. That's what triggered the investigation. And the photo looks very similar to the person on the exclusion list. We would say it's probably a 99% chance, but there is a 1% chance that it is not. We did not talk to the individual. We were not able to get a license plate photo, so we cannot confirm that it was the same person.
So take me through the hand pay, because at that point, if you've triggered that amount.
The individual, the machine locked up, gets up, and then walks out the door. And once they get to the door, they started trotting to their vehicle. So
And
the stock department was trying to identify who was the recipient of that award.
yeah, and then what happens with the winnings that's forfeited?
I believe that is,
Okay. If somebody won, forget if they're using a fig name, whatever, just normal patron, they win, triggers the hand pay of a jackpot. Do you ask for ID, a player's card? Like, what's the process?
yes, we ID everyone, do the appropriate paperwork.
Okay. Is
You're not
isn't the
collected
thresh
with that $1,200 or later.
1,200? Yeah. Okay. All right. All right. And then I saw in the response, you have updated a procedure so you could request a sort of a second form of ID
Yes,
at the entrance. Okay.
Well, in this case, he didn't even give a first form of ID. He just gave a name and a birth date.
the procedure at the time was to get the name
Yeah.
and birthday and run it against the database.
Yeah,
After
I would
this
just,
incident, we have updated our SOP.
Yeah. But if somebody came and I guess didn't have a license on them, but they had the player's card or something else, that would work.
Yeah, there's more scrutiny to go through.
Yeah. I mean, obviously the problems with people, you can only do so much if they're going to be this shifty with gaining access. But we want to know who's coming in because who knows? I mean, there's money laundering concerns, there's other concerns, but yeah. Here, go ahead, Ms. Green.
I was just say here in this situation, again, the casino, right, took the step of observing the patron, observing them leaving, doing an investigation. I get that they didn't ID him, they didn't get the right information going in. But I still think it's just important that we acknowledge what the casinos, have been doing to try to enforce this
Yeah.
rule.
Well, and the check worked, right? One of those touch points, which would be a jackpot, the guy left. I mean, it's not ideal, but it again, that's I don't pretend to be in their minds, but they're gonna enter the facility to gamble and not be able to win. Takes away the point for me, but so be it. So all right. I'm sensing a similar motion to dismiss this, but Joe or Sari, go ahead and
Yeah,
correct me if I'm wrong.
No, I'm not going to correct you. You are not wrong.
Okay. All right. Yeah, I think in all of these, one thing you're hearing in particular from Ms. Green, and I'm certainly thinking it too, is sort of the level of responsiveness from the facilities, doing your part. And I think that goes a long way. So we recognize that. Obviously, maybe, a little different if they, you're IDing people. They could still give fake IDs. They could still be shifty. There's only so much you can do. We understand that. But, I like having these brought to us. We can look at the individual facts and make a decision. So, Milt, I do appreciate sort of bringing these to us so we can see what's going on. So, with that said, is there a motion to dismiss the complaint, or I don't know, complaint, the incident report GCB 2023-80?
This is Green. I'll make a motion to dismiss GCB-80 incident report.
Seconded, hand slip.
Okay. Let's take a vote. Ms. Green.
Aye.
Mr. Hanslett.
Aye.
I'm an aye as well, so it'll be dismissed. Yeah. Well, I appreciate the opportunity to review these. So, all
Can I
right.
just get a reminder of what happens to an unclaimed jackpot?
Unclaimed. I think what you're looking at is, in this particular case, this person won a jackpot and it was withheld pending identification, was found out the person was self-excluded. So under those guidelines, that jackpot would be forfeited and forwarded to like AdCare. But
I guess that's what I'm asking. They have in the incident report an unclaimed jackpot. I understand what happened kind of moving up to it, but I guess that was my question. Just so unclaimed jackpot money goes specifically to AdCare, or is there?
Forfeitures go to AdCare. Unclaims are held for 365 days. So.
Would this have been a unclaimed or a forfeiture then?
This will be forfeiture. Well, in my view, I'll have to follow up with Vicky. I know we were addressing the situation at the time.
It's currently not claimed.
Oh, it's currently unclaimed, but it's at least our position that it should be forfeited. Now, and again, I don't want to say, Matt can certainly jump in on this. If they haven't 100% identified that person as a self-excluded person, then by all means, they should keep it as unclaimed. But if that person is in fact a self-excluded person, then it should be forfeited. So maybe that's the catch-all right now is to identifying that. And I don't know whether you can reach out to the person. I don't know what type of communication, but we'll work through that. We'll work through that with Matt.
And if it's unclaimed, is it at a certain amount of time, then it goes to AdCare?
No, it doesn't go to AdCare at all. 365 days. They hold them for 365 days and then it's turned back into revenue.
So I'm sorry, one more question. So help me understand the difference between forfeiture and unclaimed.
So if I'm in the casino and I hit the payout ticket and it's a $200 ticket and I'm in a hurry to get out the door because I have an appointment to go to or catch a plane to Florida for the next 6 months, that ticket's not validated. And so they have 365 days in order to validate that ticket. If not, it becomes invalid at that point. Forfeiture is if we find you on the casino floor as a self-excluded person, then they withhold that jackpot payout, and like in this case, and that money gets forwarded to AdCare or DHHS.
Thank you.
Do you want to add any more? Okay.
All right. Thank you. All right. So with that, we're going to turn to the ADW public hearing. And if you remember in November, we dealt with some of the rules, and I thought it would be best to have sort of an opportunity to hear from commenters while we decide a few issues. So we will shift into ADW mode. And it is 10:36 a.m. on January 16th, 2024. So I'm going to call a public hearing to order. And again, my name is Steve Silver. I'm chairman of the Gambling Control Board under MRS Title 8, Chapter 31, Subchapter 7, Advanced Deposit Wagering under the authority of, 8 MRSA subsection 1003 1B. So I don't know what that is. Is that L3J? 13J? I can't tell. And Title 8 MRSA sub 1031 subsection 1. It's a lot of statutes. Notice of this hearing was published in the Kennebec Journal, Bangor Daily News, Waterville Morning Sentinel, Lewiston Sun Journal, and the Portland Press Herald on December 27, 2023. Notice was also posted on the websites of the Bureau of Corporations, Elections, and Commissions and the Gambling Control Unit. Copies of the notice and the proposed text were individually sent to persons who requested copies after the publication. Are there copies in the room? I don't know. Assume so. And so the purpose of this hearing is to allow the Gambling Control Board to receive any comments or other information that interested persons or parties may wish to provide regarding the potential rules for advanced deposit wagering. Before starting your testimony, it'd be helpful to state your name and the company or organization you represent, or if you're just individual person of interest. Some may not be familiar with some of the industry terms or acronyms. So, if you're using them, say what it is. For example, ADW, Advanced Deposit Wagering. We're not going to discourage anyone from addressing any of the provisions within the proposed rule. However, of course, it would be appreciated if the same points are not repeated numerous times. If you agree with comment someone else has made. So the purpose of the hearing is to accept testimony or comment on the proposed Gambling Control Board Rule, Chapter 28. There's also an opportunity to submit written comments as well, and those have to be received no later than the close of business on February 16th, 2024. Comments received after February 16th will not be considered. Those comments should be emailed, can be emailed to Director Champion, milton.f.champion@maine.gov, or you could physically send them or drop them off at the Department of Public Safety, 45 Commerce Drive, Suite 3 in Augusta. So final decision on the rules, Chapter 28 will be made by the board at a future meeting. Board members are not supposed to debate the rules with any of the commenters, but certainly, we can listen and perhaps ask questions if need be. The purpose is to hear from the public. And also, as I mentioned, the rule was published initially on October 4th, 2023. I believe that's right. We received written comments. The board made some decisions during its November 2023 meeting in terms of rejecting or accepting some of the comments. But there's still some items that were left unaddressed. And, certainly if anyone feels it's necessary to revisit portions we already discussed, we can. But, I'd like to focus on the unresolved parts of the rule. With that, we'll turn to testimony. Let me pull up. We're at it's the second publication of the text. It's that file, right, Mel?
Yes.
Yeah. So what I'd like to do is go through section by section versus just open it up. And certainly we can also have an open session, but it was really effective for sports betting when that was done. So that's where I'd like to go. If you're on Zoom, you can use the hand function. I can see Lou, he turned his camera on. So, and if you're in the room, speak up. I can't see that back part of the room. But any questions before we go forward? Okay.
Mallory, you can turn the camera towards them. Yeah, thank you.
So the first section are the definitions, and I know that there's a definition of the SOC 2 Type 2 that may be an issue in terms of what's required, but I just want to focus on the actual definitions at this part. Anyone have comments on those definitions? It's section 1. Okay. We've got section 2, which states, the board's authority over the licensing. Any issues there? Okay. 3 sets forth some things with the license. Lou, go ahead. I saw you raise your hand.
Yeah, so I guess we'll take 2 and 3 sort of.
Yeah, go ahead.
Apologies. Could I just have you introduce yourself and state your name and for the record? Thank you.
So my name is Lou Frascogna. I am an attorney with Churchill Downs Incorporated, which is the ultimate parent company of Churchill Downs Technology Initiatives Company, which operates an advanced deposit wagering or ADW operation under the name Twin Spires. We've made, I think we had 3 comments in the initial round of public comment, and would like to reiterate those. And so as we're stepping through, this is the first of our three comments, which is on sort of licensing in general. The issue that we've identified is kind of a disconnect between the statute and the rules as written. So in theory, there's nothing wrong with the rules. The issue is the statute is overly expansive and the rules don't seek to narrow that down. So the statute itself says something to the effect that all employees should be licensed, except where the public interest is not served by the requirement of employee licensure. But when we look at the way the rules are written, I think that there is some discretion that the board is engaging in. The board shall exercise authority over licensing of all persons conducting advanced deposit wagering. So this is a pretty broad section, or I guess writing of this, and when read in conjunction with the statute, then you would assume that every individual, every employee of the ADW operator would need to be licensed. Obviously there's employees that don't have anything to do with Maine. There's a number of employees that whose function is sort of back end to a certain extent. And, we would, we had asked that the rules include something to the effect where it gives us some guidance or self-limits. Obviously, we can all sit in the room and talk about who's actually going to receive a license, and we can get assurances from the current board and unit that it'll only be, let's say, key people. But we think at this point it would be wise to sort of identify what that scope is.
Yeah, and Gene, I see you've got your hand up, but Milt, I thought that we dealt with this in November, where the unit would be adding some clarity as to who needs a license.
I thought that at the time it was going to be at our discretion because we don't know what those titles are. And each operator, I mean, if we're anticipating 8 to 10 operators, they're all going to have different titles, different names, different functions. And so we thought it best be left up as a discretionary situation where once we get their job descriptions, irregardless of the title, but once we get their job descriptions, then we can identify, as we have in really all other areas of oversight, we could identify who we feel will be necessary to have to be licensed.
Okay. Gene, I saw you had your hand up. Do you have a comment on this? Can you introduce yourself?
Yeah, Gene Shabrier. I'm with ExpressBet. We're an advanced deposit wagering company, for those of you who are not familiar. I agree with what Lou had said earlier. We just, that was one of our issues as well, as, we want to know the scope of licensing. I think Milt, we would like to work with Milt on, getting that to a decision maker level of the operation. That seems to be the pattern in most other states. So that is my comment.
Okay. And so, Milt, in November, I'm looking at the basis statement. There was, proposed language, because the public interest is not served by the requirement of employee licensure for all employees of an advanced deposit wagering licensee, an employee is not subject to the requirement if they're not physically located in the state or involved in the control of the conduct. So was that proposed language was not included in the second publication? Is that right?
And you're looking at subs 2 and 3? employee license requirements.
Yeah,
Yeah,
but I thought that we had, my understanding was that the board wanted that language in there.
yeah, and well, in the board response, the comment was accepted with clarity that the unit shall decipher who needs licensure. Proposed employee license for public hearing. Again, this would be a hard thing to do because each company has different titles for their employees. That's
Right,
why I
but
say job description is really the more important one. And, you know, I honestly think that the unit can work with the licensees as we have in other areas to establish, gee, this person's clerical, or that person doesn't do this. This person doesn't have anything to do with wagering, you know, that sort of thing. I think we can be clear. Now, if you want us to
Well-
meet with them, meet with potential licensees and have them give us titles and all that, that'd be another thing. But I think that'd be
well, why
hard
can't we,
to accomplish.
why can't we insert that proposed language? Because it still gives the board or the unit discretion, but it provides some clarity that if they're not physically in Maine and they don't have control, you know, I think that at least narrows it a bit. Probably not to what some of the comments we've heard want, but you know, they're not going to have to submit, you know, for a paralegal or a secretary or others, you know, who are working in Kentucky, you know, that may touch some paperwork for this, right? Like they're not controlling the operations. And then of course, some of it's going to depend. I mean, we see that with the casinos. There's certain positions that we debate sometimes. So I don't know if Sari or Joe have thoughts, but I would add that proposed language from the basis statement.
The only thing that I would add is to take out the physically located in the state, because there are persons involved in the control and conduct of advanced deposit wagering licensees operations outside of the state.
Yeah,
Right?
I read it.
So,
I read it as it's if they're outside of the state and not involved. So maybe it's a word choice thing, but the way I interpret it is you could still be outside the state and need a license if you're involved in the control of the operations. But maybe the AAGs can wordsmith that.
yes, I'll work with them on that.
Okay, so yeah, I'd like to see that added in. Probably not fully what we just heard, but may help a little bit.
Okay.
Any other comments sort of about section 2 and 3 about those licenses? Okay, I do want to turn to section 4 because there was an issue that came up with the, I guess it's 41K about, you know, getting this, I don't know, notarized statement from the tracks. Anyone have comments on that? I see Michael, you want to introduce yourself?
Yeah, thank you, Mr. Chair. Thanks for having me today. Michael Chiquette, manager of First Tracks Investments. We're the commercial track presently operating from the Cumberland Fairgrounds. And as the chair noted, we had submitted written comments on the prior iteration. And I know there were some conversation about this at the board meeting, so wanted to make myself available. The genesis of this, and I thank the board and the staff for including it in this draft. But essentially, as the board's heard today, there are several large reputable operators of ADWs, Twin Spires, ExpressBet, TVG, certainly Hollywood, who's been the contracted licensee over the past several years. And we have great relationships with all of them and don't have any concerns. However, under the statute that the legislature passed any ADW that's licensed in Maine needs to carry our races if we make them available for simulcast as a condition of their licensure. There are some small operators who, theoretically could come in, apply for a license to start in January of a given year, and where we may not start racing until April or May, have some period of time where they're not carrying our races. Lo and behold, we begin racing. They haven't agreed to carry our races, and then it places, I think, the board and the unit in a enforcement situation following a complaint. So the intent of this comment was really just to try to check the statutory box ahead of licensure rather than after licensure, just to ensure that we're all in sync moving forward. No pride of authorship in the particular language. If the board or the staff or the AGs have suggestions to further clarify, but intentionally, or the intent of the suggested addition was to, again, have an ounce of prevention rather than a pound of cure in an enforcement situation.
Okay. Any other? So, all right. So walk me through. I'm not debating, asking a question. So I guess I'm not understanding. So ADW operator comes in, they want to offer bets from around the country, but they need to have an agreement with each track in Maine.
Correct. So under, and I'm not an expert in the federal law. Potentially one of the folks from the ADWs may be able to explain a little bit more. But essentially, in order to offer interstate wagering, so for someone from New Hampshire to access our races, they, under the federal law, they need to have a contract with us in order to access that pool. So in order for an ADW to be licensed in Maine, they have to carry our races. It's the same requirement that's placed on the off-track betting facilities in Maine, that they are required to carry Maine races. So essentially, it's an equity provision trying to place ADWs on par with off-track betting facilities as well as commercial tracks.
If there's a track in Maine that doesn't want to do that or is charging some exorbitant amount for that agreement, then the ADW can't operate here.
I mean, I guess theoretically, I suppose I hadn't considered that. It's essentially, again, in order for it's the same as, again, it's the same as the OTBs, the various inter-track settlements that occur in state is spelled out by statute. Again, I know that lives in the harness racing commission world. So I suppose theoretically, yeah, that could, if one of the fairs said we want $1 million, that could hamstring an ADW. And obviously, I think if that happened, everyone would be back at the legislature looking to adjust that statutory provision.
Does the current single ADW licensee, they have these agreements?
They do.
Okay. I'm just looking at the statute now. Mill, anything to add?
No, not at this time.
Okay. All right. Also, while I have you, Michael, get your horse harness people on board. We need a new board member.
So I do know that the governor's board and commission staff have had several names.
Okay.
Where that stands in their internal process, I don't know.
Okay. Well, keep me posted. We would like to have a new member. If I can do anything, let me know.
Yeah.
To push some people forward. All right. All right, let me go back to the text here. Any other comments on section 4? Okay. All right. All right, I suspect this will have some comments. So section 5, and again, we can talk about anything in section 5, but it's subsection 9 about SOC 2 type 2 audits. Lou, go ahead.
Hey, Lou Fresconia with Twin Spires again. We'd offered this comment back in the initial comment phase and renew it. And for the hearing today, ultimately, this is a first of its kind regulation for ADW operators in the US. And, you know, although I guess twofold. One, because this is such a unique requirement, you know, our first request would be that SOC 2 Type 2 audit requirement not be included. The second request would be for additional clarity on who is actually subject to this review. Obviously, we have data centers that hold data pursuant that might be subject to a SOC 2 Type 2. Those physical controls that we use as a part of the offering, as well as on our operation. And we would urge that like additional clarity be given. Alternatively, I'll note that the current single operator does not or did not have to have a SOC 2 Type 2 audit to go live or to continue operating. So this puts a new burden on potential new entrants into the market. And with that in mind, not only is it a new requirement, but it says that the copy of the audit shall be forwarded to the director by June 30th of each year. For the previous calendar year, we would ask that there be some sort of consideration given to new operators, given that obviously we would not have a year of operation in Maine to go on. So there would be need to be some clarity on whether that was the expectation, that if you didn't operate in Maine last year, or if your entire national operation is covered by this SOC 2 Type 2. So we would at least ask for clarifying language that this wouldn't be due until, you know, a year after its first year of operation or something like that. So I guess that the first SOC 2 Type 2 audit for a new operator that starts in, say, May would be, so you'd have a year of operation in 2025, and then in 2026, you would submit a SOC 2 Type 2.
Do you know what, and I mean, maybe someone from Penn knows, but what's being, or maybe what's being used now for the current ADW operator? Is there some auditing done?
No, somewhat. I mean, we can ask for reports if there's any discrepancies, but we really haven't seen any. There just hasn't been a huge amount of revenue generated, so.
So what's the purpose of adding this in now?
Because typically, well, basically what I'm trying to do here while I'm the director is trying to have uniformity in all areas that we oversee. It saves us from going completely bonkers, because I got to put the ADW hat on, then the casino hat, then the, you know, fantasy hat, then the sports wagering hat. Now we got iGaming hats and all kinds of hats. So if we can bring all this in and be the same, it certainly helps us out, especially for guys like myself who are getting a little bit older.
Milt, should we infer then that you're going to want to do a SOC 2 Type 2, which you all know how I feel about that anyway, but on everything, that we'll start seeing this implemented in casinos, in slot machine operators, et cetera? Is that ultimately your goal?
Well, I through discussions with Maine IT, basically what I did was I was looking for something other than a description of assessment, right? a lot of other jurisdictions say, oh, you got to do an assessment on this, assessment on that. Well, what is that assessment? Is that walking into the server room and making sure all the lights are shining and bright and all that sort of thing? Or do we have a particular standard? So we've put it in sports wagering. We just had rules adopted. We put it in fantasy. And so we're just moving forward by placing it in all areas.
But
Okay,
isn't
so
that
I
a-
guess,
Yeah,
But
sorry.
that's,
Go ahead, sorry.
But that's also up to you as the board too, right? You don't have to have it just because we have it in other areas.
Well, there's also an order of magnitude, right? I mean, sports wagering is taking in a significant multiple of dollars that ADW would. So just in terms of the burden, and I think we have to weigh that. But Ms. Green, go ahead, and then I do have questions for you.
questions for me?
Yeah.
Oh, well,
Well, I
why don't you
mean,
start with those if you'd like?
Yeah, I mean, I guess we've heard, we heard in November, we heard now. I mean, is there something else that can be done? Like,
Well, I think there's a couple of things that here, a SOC 2 type 2 audit is a good tool for due diligence. I don't dispute that. I almost have never seen a SOC 2 type 2 that includes all 5 trust principles. That is extraordinarily unusual. There are 5 trust principles that then are generally determined by the organization, what they feel should be covered, and then the criteria is by the AICPA, the American Institute of Certified Public Accountants. So I think this happens to be particularly onerous. I think it's unusual. And I think a really good point was made of exactly what do you want this SOC 2 on? Do you want it on the data center? Do you want it on the software company that provides the application? Do you want it on the managing organization? I mean, there's a real lack of clarity. I think it is particularly onerous. I think it's too extensive. And while I think due diligence is really important, I don't think this is the answer.
So would we remove all that language, or is there some alternative that would be proposed?
Yeah, I was hoping someone was going to reach out to me from the office in the last 2 months as we were talking, as we expected at the last one. I think that there is language perhaps that can be due diligence. Well, I think we have to decide who we want the due diligence on first and why we want it so that we can determine what we're looking for. Maybe there's an array of reports, maybe there's an equivalent to a type of information that we are looking to get. But I think just because someone in IT said, oh, a SOC 2 type 2 is a great report, I don't think that's a reason to go forward. And I really don't want to set the precedent that all of a sudden we're going to do this across all of our areas.
So, yeah, well, I agree with that. Okay.
Can I
Trying to
interject
think.
just a moment here?
Who's speaking?
Matthew Motti, Deputy Director.
Go ahead.
Well, what are the 5 principles of
They
this
are
document?
confidentiality, availability, privacy, processing integrity, and I can't remember the 5th one at the moment. Sorry, off the top of my head. But generally, an organization will choose maybe 1 or 2 of them. Maybe it's privacy. Maybe, it's security. It's just the other one. Maybe it's processing integrity is what we care about. And so, it tends to be pretty common that maybe 2 trust principles, maybe 3 are in a SOC 2. I done a lot of review of these, and I can't even recall seeing one that had all 5. I mean, that's a big, very, very expensive process. I mean, when, in one of the comments, it talked about $50,000, and I don't think that's an overstatement.
Of those principles, which ones would we leave out? The ones you just mentioned, I think are all important. Security and integrity of processing and.
I think it depends on who we're asking this of. Are we asking it of the data center? Are we asking it of the software folks? It kind of depends on who we're expecting the SOC 2 report to come from, because it sounds like in the way the ADW is presented, or this how the ecosystem works, there may be multiple required. So I think that question has to be answered first. Is what is it that we're trying to determine here?
Well, the current language proposed says audit that includes all 5 trust principles shall be completed by the licensee for the previous year on any and all advanced deposit wagering systems for use in Maine or to support Maine advanced deposit wagering activity operated or maintained by an advanced deposit wagering provider.
Yes, thank you. I can read that. But the
So-
question is that necessary? Are you really looking for them to do maybe 3 different SOC reports? I mean, I guess that I'm kind of going back to the same issue we had with surveillance, which is let's make a compelling case of why we need that before we require it.
Due diligence?
But yes,
In
due diligence is
protecting-
due diligence is very important. I'm not looking for the abstract. Due diligence is important. But what is it that you wanted? Which do you want to know? And do you want 3 different due diligence SOC reports here? Do you want it on all 5? Let's figure out why that is. Not because you know, in the industry, not in the gambling industry, in general, in industry, you know, we figure out, okay, these guys, let's say, are providing software. So this is what we want to know, right? We want to know that they have the confidentiality and privacy controls in place if they're collecting customer data, for example. So again, due diligence, I'm not disputing that. Really important. Do I want to see assessments? Absolutely. I think understanding the technology controls of these organizations is very important. I'm not disputing any of that. I just think what we're asking for is onerous and may not be the right answer.
Well, I would say, and again, this is just a suggestion, but I mean, if you want to come back and propose some different language other than just an assessment, then certainly you have the ability, you have the ability to do that.
So I'm going to jump in. Gene, I'll turn to you in a second, but I think it would be useful, Lou or Gene or others, because there is, you have till a month to submit written comments. If there's language from other states, or not from other states, but you would prefer, like, I'd like to see some alternative proposals, right? I do not pretend to know what the ADW regs are in other states. I could probably tell you about sports betting, but not in ADW. So that would be useful, right? If after this you can submit something, right? Hearing the concerns from the unit, right? We obviously want to ensure integrity and security and all of that. Is there some other less burdensome way to do it? That's what I'd like to know. So with that, Gene, do you have something else to say?
Thank you. Again, this is Gene Shabrir, Vice President of Regulatory Affairs for ExpressBet. You know, I think Ms. Green summed it up perfectly. They really don't have a clear target with what you're asking for here. But I would like to offer an alternative, and that, I know, myself, Twin Spires, TVG, we're all licensed in Oregon. Oregon comes into our operation every year and does a extraordinarily deep dive audit into all of our systems, both technical, make sure that, that we have all the procedures in place to protect the customer information. And, I'd be more than happy to share that with the commission there in Maine, on an annual basis, once this audit is performed. And, and even if Mr. Champion would like to see one now, I'd be more than happy to provide him so he knows how in depth that this audit is, so that he has a level of comfort with that. I'm sorry, it looks like you froze up. Can you hear me?
Yeah, I can. Maybe there's I don't know, maybe there's language from Oregon that we can look at.
Sure. But they do have an auditor that comes on site and,
yeah,
reviews accounts, everything.
Yeah, I mean, we can do it ourselves as well. I think we just need to know how, it needs to be specified what exactly needs to be done. So, all right, I think on that issue, think everyone knows where people stand. It'd be useful again for members of the public or the entities if you can submit some written proposed language that we could consider. So, anything else? I think we've covered it. Okay. Section 6 is investigations or inspections. Any comments? Okay. 7, claims of non-payment. All right, and this one I assume we will have some comments. Section 8, promotion and advertising. Lou, your hand is raised. You want to kick us off?
Yeah, I'm pretty quick with that reaction button. Our comments, again, echoing from November, is that the issue here is that the nature of ADW advertising and promotion, especially when conducted online, this regulation would be particularly onerous without some sort of specificity or direction as to what is actually being requested. Currently, it says all advertising, marketing, branding, promotional materials, promoting or intended promoting any ADW, including when, how, and with whom those materials have been published, aired, displayed, or disseminated for 3 years. So, this creates an issue when you talk about serving up Google ads. A lot of times those are just done with keywords, and then Google goes out and disseminates that to individuals based on an algorithm that they have. Additionally, the way that we advertise, some things are national, some things are directed at the state of Maine. For example, a Maine-only promotion could be said to be, okay, well, that's directed at Maine. But then, throughout the years, can't imagine how many number of promotions or advertisements are served up across the country. And again, just like we serve up ads maybe that are directed specifically at Maine, there may be ones specifically in other states, which would have no bearing on Maine. So I think that we are looking to just include some limiting language. One thought would be that you can maintain representative advertising terms and conditions. For example, you may have a type of ad that is served up and it is put out online, and it's right now the rule would say every variation of it. Let's say there's a small one, there's a banner ad, there's a larger one, there's a full screen one, but it's a single type of campaign. So you would say, we would just keep a log of campaigns conducted and the terms and conditions of those campaigns, as opposed to every image that gets served up, how it was served, what websites it was displayed on. In certain situations, we may not even have that information. So I think there's a potential with compliance that may make it impossible to comply with, just because some of the stuff of with whom and how it was displayed, we may not even have all of those use cases. And then second, that it would currently apply to any ad campaign run anywhere in the country, as opposed to just directed at Maine residents. I think last time we discussed that in certain sports books, specifically Pennsylvania, they have a similar requirement, but put out guidance as to who that would apply to or when that applies. And ultimately it was advertisements directed at Pennsylvania residents. So they sent out kind of a list of examples, direct mail pieces sent to Pennsylvania residents, billboards located in Pennsylvania, newspaper print publications that are based in Pennsylvania. So if you put it in the Pittsburgh Penny Saver, that's an advertisement you should retain because it was directed at Pennsylvania residents. If you put it in the New York Times, that would be something that was, more broad. It wouldn't fall under the regulations of Pennsylvania Gaming Control Board. So sort of a similar direction here. So those would be our two suggestions.
Yeah. And, I agree with that concept. Mill, any reason why this needs to be as broad as it is written?
No, I was just pulling it in from other areas that we've had, that we have this direction in, and you can modify it.
Yeah, I mean,
Obviously. So, yeah, it's just to get the conversation started, really.
Yeah, I mean, I'd like to see it with some limitations of things that are actually, in Maine, targeting Maine. The sort of Google Ads, affiliate links, that stuff is really hard to track with this. I also I don't know, do we care about social media posts by others who are not, from the actual operator? I don't know. Maybe we do, but I don't see why. Certainly, okay, they can disclose where they advertise if it's on Instagram or whatever, but does that even count, right? So if you put a post on Facebook, it's not directed necessarily at Maine. Does that count? I think we need some clarity on that. And yeah, if you're putting ads on a bus in Maine or in the Press Herald, yeah, certainly. They have all the details of that. We can keep it, retain it. That makes sense.
Well, I think that you can put ads on Google. It's not just I don't think a post with anybody else makes sense, but you can do paid advertising. I agree that it would be almost impossible to be able to pull all the variations, but I could see adding something here about to make available upon request any of the analytics that are provided by the platforms that you do online advertising with. So, because you can go to Google and say, give me Google Analytics, give me whoever you're using. I'm not sure how useful they would be, but if we really wanted something, I think that we had access to the same type of reporting that the operator would get. Is
Yeah, I mean,
not onerous.
Yeah, well, I just guess why do we need it, right?
Oh, yeah, I don't know why we need it. I was just saying how we could get it.
I think if there was an incident where we thought there was directed marketing towards excluded patrons, and that may be something that we would request, right? But sort of in the regular course, I don't know why we necessarily care. So, I think well, I guess we'll get some written comments, but I'd like to see that section narrowed down to focus specifically on Maine based advertisements. So, I don't know, Milt, if you need more from the board than that.
No, I think realistically, this is just to establish a way that if they have a promotion today or they have a promotion 6 months ago and they get rid of that promotion and then we get a complaint or several complaints and we don't have copies of them or we don't have access to that particular promotion, that might be, or that's really the rationale around a lot of this, keeping logs for periods of time and all that sort of thing. I mean, if you want to drill it down to just 1 year or bring it in a little bit tighter, certainly you have the ability to do that. But for the long haul, it's really for us short of us having to bring things into possession. We don't want to possess anything. We don't want to create the data and all that sort of thing, just to say, that's why we've been saying, you have it, you keep it. And if we need it, we'll contact you later.
Yeah, right. I mean, I get it. You don't want the, place a risk-free bet, and then it's not actually risk-free, right? And you get a complaint about it.
Yeah.
And it's suddenly vanished from the internet. There's no proof of it. I don't think that's what's proposed here, right? It's just being a little more narrowly tailored. So I think we could do that. Again, if people want to submit written in this next round of written comments, like actual proposed language changes, go for it. Otherwise, we'll take a crack at it. But anyway, sounds like there's some universal agreement that there needs to be tracking and retention. It's just sort of how do we craft that? So, we're not far off. Okay, and that was that particular subsection. Any other comments on the advertising? Okay. I think we fixed the hotline issue last time. Section 9, establishing an account. All right. I'll just we'll go through 10, account information. These are very short sections. 11, identifying an account number. 12, secure personal identification code. 13, principal residence. 14, information received by account holder. All right, 15, close or refuse to open an account. 16, account holder responsibilities. 17, operation of an account. 18, credits to an account. 19, debits to an account. We're getting there. 20, wagers in excess of account balance. 21, accounts will not bear any interest. Okay, 22, payments on winning pari-mutuel wagers. Okay, 23, mailing address. Okay, 24, powers of the Gambling Control Board to review and audit records. 25, confidential information. Okay, 26, applicable laws. Right, 27, collection of payments from advanced deposit wagering licensee. And 28, penalties. All right. Any other members of the public have comment about any portion of these rules? Okay, any board questions or comments? Okay. So, and I would just want to make sure we're summarized in the right place. In section, okay, so there's still the month. We have another month to get written comments, right, Milt?
Correct.
All right. I see it as we want to add in that proposed language, which is at the bottom of page 2 of the basis statement, into that section 2.3 with employee licensure requirements.
Yes.
Then where are we at here? Okay, all right. Then we're gonna leave in, that's fine, the main tracks. Then that 41K. The SOC 2 type 2 audit is probably going to be taken out or modified, but we'll see what written comments we get on that.
Right.
And then the advertising section will probably, will be modified in some manner. But, I think we're in good shape. There's only a few specific items that we're going to need to meddle with. Everything else looks good. Does that make sense? Did I miss
Yes.
anything? Okay. So is there anything that's needed from the board today? Or we will wait till the written comments come in and then we'll make final decisions on each?
Nothing is needed from the board today.
Okay. So we've really got two main areas that we're going to need to fiddle with, I think. But it's pretty good, my opinion. So for those in attendance and listening, you have again till February 16th to submit written comment about any portion of the rule. It doesn't just have to be those. And you can send that to email to Director Champion at milton.f.champion@maine.gov, or mail it, or I guess physically drop it off at the Department of Public Safety, 45 Commerce Drive, Suite 3 in Augusta, Maine. Again, until the close of business on February 16th, 2024. So I'd like to thank everyone for attending and bearing with us today. If there's no further comments, all right, then I will close the hearing, and the hearing is now closed. So with that, we will go to any board business. Sarah or Joe, do you have anything? Go ahead, Ms. Green.
I do. I just want to express a concern. I understand Director Champion's desire for uniformity. I totally understand that and I support that. But I am really concerned that what's happening is that there are rules that were published in sports betting and perhaps in other areas that we had no oversight on, that were not vetted, we were not involved in hearings, and those are now driving rules that we're looking at, and I don't really know how to frame that right, but I'm really concerned about that. I feel like those things that we didn't have oversight on are now encroaching into the areas that we did. And with this argument, reasoning for uniformity, it's just going to make things very difficult. And I just wanted to express that concern.
Noted. And yeah, well, got to hold the line. And also maybe somebody at the legislature would pay attention as to when they pass these laws as to who governs what. I'm sure Milt would love to have some responsibilities off his plate too, but they seem to keep putting everything on him. So, yeah, that was actually one of the comments I made in response to this iGaming thing, which is, it's involving casino games and potentially the casinos. The board needs to be involved, but not up to me. So we'll see.
Yeah, and if I may, Mr. Chair, I mean,
Yeah.
I bring these forward as recommendations. I don't have a stronghold on any of this. Certainly you have the purview of making the final decision. So all I can do is just bring this forward to you and the decisions for you to make. So just know that there's no sidebar to this or no prerequisite or anything like that. It's just me bringing forth some recommendations, just like everybody does when they give written comment. So I just want to make that clear as well.
Director, and I appreciate that. I just and I do support your need for uniformity, and I guess that's really more my concern is when we have these different areas of oversight, it makes uniformity very difficult.
Yeah. And I'll be honest with you, from my previous experience, it was the same scenario. We had 5 different divisions overseeing 5 different things under the same roof. So I'm very familiar with the change of hats, if you will.
Yep. All right. Well, I do appreciate. Yeah, I appreciate everyone's participation, and I wanted to have this hearing. I know it extended the meeting a bit, but I think it's useful to hear from, the operators, who deal with this across multiple states. So, with that, is Austin still in the room?
No.
Oh, okay. All right. I was going to ask him. I'm thinking maybe we'll have a meeting up at Hollywood in May. So just ponder it. March, there's still potential for snow. May would be pre-summer vacation. So, we'd still have a Zoom option, but I'd like to get up there since I think having the meeting at Oxford was useful. So that's what I'm eyeing. Obviously, it's a long way off, but consider it. All right. So with that, any public comment on anything? Okay. The next meeting date is March 19th at 9 a.m. Hopefully we'll all be in person in Augusta, but I'll keep everyone posted as things develop. And with that, I will entertain a motion to adjourn.
Motion to adjourn, hand slip.
Green second.
All right, let's take a vote. Ms. Green.
Aye.
Mr. Hanslip.
Aye.
I'm an aye as well. We are adjourned. See you all in March.
Thank you.
Happy snow blowing.
Drives.